Good evening, this is Rahul Reddy. Reddy Neumann PC presents Facebook and YouTube Live every Tuesday at 5 p.m. Central Time. For those people who are listening to this one, you can post your questions. We'll try to answer as much as possible. Emily, what are we discussing today? It's a year ending and New Year is about to come in a couple of hours. In some of the countries, it's already New Year.
Yeah, Happy New Year to everyone who's been joining us for all these weeks when we give you this news. We wanted to give you kind of an overview of what we saw in 2019 from an immigration standpoint, particularly for employment-based immigration, and what to expect in 2020. 2019 was a pretty rough year, I would say, for employment-based immigration and applications, and I think 2020 is going to be more of the same from what it looks like.
So let's discuss, Emily, let's review what happened in 2019, and then let's give the realistic picture of what the USCIS, ICBP, the government is planning in 2020 for our audiences so that they can be prepared. Can can we go over what happened in 2019, Emily?
Yeah, I mean, the year started off with a bang for immigration because right on January 1st at midnight is when immigration attorneys everywhere were trying to file their H2B visa applications through the iCert website, and it crashed.
And it is first come, first served basis. Normally the quota finishes in one day, and they made it an online system. First day itself, the whole system crashed out. It was a big nightmare. A lot of immigration lawyers that were working in the middle of a night, they had a horrible time the new year. These people, instead of going celebrating in the new year, they're actually working in their law offices at midnight, yet you have the crash. That's how 2019 started. The USCIS has passed a memo in August 9th of 2018, which was effective in February of 2019, because 180 days counting from August 9th was effective on February 1st. It became effective, however, the court blocked it in May of 2019. If the court wouldn't have blocked it, it would have been a significant impact to a lot of people, though. Emily, can you explain what happened in the court on this?
Yeah, so if you remember August 9th, 2019, the Department of Homeland Security implemented this memo saying that unlawful presence specifically for F1 students could be defined retroactively, not on the day that you are found to be in violation, but going back to the day the violation that began. So many different organizations filed lawsuits to block that memo. Some universities, particularly in California, were instrumental in bringing lawsuits on that. The lawsuit is still ongoing. So the only thing that's happened is that the judge in various lawsuits, all the different courts, found that the people bringing the lawsuits against USCIS, against Homeland Security, are likely to prevail in their lawsuit, and therefore they issued a preliminary injunction stopping the memo from being enforced while the rest of the court process goes through. So the court case is still pending. We're still going to be seeing oral arguments, waiting for the judge to make a decision on it. There's a chance the judge at the end of it all could say that the memo was lawful and it goes back into effect. So it's definitely not over, but at least right now it is blocked.
And on the H4 EAD lawsuit, Emily, what happened in 2019?
Yeah, so if you remember, this H4 EAD lawsuit's been going on since the H4 EAD was implemented all the way back in, May 2016? It's gone up to different appeals courts, gone back down. The lawsuit was eventually put on hold because the government came out and said they were planning on issuing a regulation. The regulation was taking so long, we still don't have a regulation, not even a proposal, that the judge finally had enough and said, all right, if you're not moving forward with this regulation, we're going to move forward with this lawsuit. So the lawsuit is still ongoing. There's a chance a judge could say that the H4 EAD is not lawfully created. There's a chance that the judge could side with the government and say that it was lawful. Or there's a chance that we might have a regulation that makes the lawsuit moot, meaning we don't need to decide the lawsuit because the regulation doesn't exist anymore. So lots going on with the H4 EAD, but it continues to be available for now.
Also in 2019, they suspended the premium processing, but they reinstated the premium processing by phase basis, especially the quota time they did suspended, and then they started releasing in.
Yeah, I was looking back. I think the quota from April 2018, we finally could file premium in January of 2019. So that was a long delay for people who were waiting for those, and then just all the different types of cases.
Yeah, but for in the 2019 April though, they did allow it for the quota filing. It was a 2018.
For the change of status, yeah.
So which was actually, it's a better than last year, 2018. This is one of the good news compared to last year, because in 2018 most of the premium processing we couldn't do it, but in 2019 right now practically everything we can do it.
Yeah, hopefully that's a good sign for 2020, especially with this new version of the lottery. So also something that happened in 2019 is the regulatory process was finished for creating the new electronic registration system. So this takes effect March 1st. Instead of companies preparing all of the H-1B petitions that they plan to sponsor in the lottery and filing the petitions, now before the lottery happens, we will be submitting names electronically from March 1st to March 20th. USCIS will run the lottery based on that, and then beginning April 1st, only those that were selected will be filing in the lottery. I think that that is going to be very helpful for a lot of employers. It's going to be helpful for a lot of employees who need to know what's going on. It's very difficult to wait a month or two to find out if you were selected or not, so this should be much faster. Hopefully it means premium processing will be available for all of them. So hopefully that will be a good sign.
Yeah, this is one of the good news in 2019, other than the premium processing, to have the H-1B lottery in the quota before, and all the unnecessary work done by the lawyers, the HR, and the administration of the company has been eliminated. Also in 2019, February 2019, University of January 30th or February 1st of 2019, the government has unveiled that the University of Farmington is a fake operation. It was a complete fake operation. So they started arresting people on February 1st of 2019, early morning, starting at about 4 o'clock in the morning. They started arresting. They arrested about 200 people. Any more news on that, Emily?
Yeah, I mean, it kind of came back up in the news recently as more people were arrested. Around Thanksgiving time, they updated that number. And even just over this past weekend, for some reason, ICE feels the need to add insult to injury and start showing videos about different students and how they tried to entrap them into this school. So they're using it as a way to portray these students in a very bad light, make them look like they were doing things that they knew were illegal and did them anyways. I think that it's very disingenuous how they're portraying these students, the situation that they put the students in. They specifically targeted these students as they were trying to transition out from other universities, knowing that they were in a desperate situation.
And they released this video on December 29th of 2019, which is like 2 days ago. Although they only showed about maybe 3 or 4 students that came in for the admission, I wish they have the recordings of everybody, because normally in the criminal prosecution, they'll have to show evidence of each and every person though. Especially this is a deportation, the people don't have the equal rights, like the same way what the people who have in the criminal proceedings have the rights. So they only showed a sample of them, they didn't show the rest of the people, because most of the people that I spoke with, they never went to the university, Emily. Most of these people spoke with the recruiters, so there is another side of the story which they are not releasing it in the ICE though.
Also in 2019, we saw another increase in the number of petitions filed in the H-1B lottery. It went up to 201,000 applications filed. Again, the good thing is that it'll be different this year. We're not going to be filing all of those petitions, so it will save a lot of time and energy. But with the new electronic registration, I'm thinking that number is going to skyrocket, at least as far as the number of people who are going to put their names in the hat.
They should have restricted some way that a person should be only filing one application. Somehow, we know that these fraudulent filings will be prosecuted, but most of the innocent victims, they don't know that just giving the names to the different employees is not a good idea. especially with the $10 fees. It's not a good idea for people. So please be wary in the 2020 filings. If you're not working for the company, please discuss with the lawyer before you file. You give the name to some other company because they don't need much information to file in the lottery. A new thing that came out in 2019 is the social media questions that came out in the visa application when people go and get for the stamping at the DS-160. That was newly introduced in 2019 that added more delays in the visa processing times in the consulates. Also, biometrics have been introduced for the 539 applicants, especially for those people on the H4. Even for kids that are 2-year-old, they have to go for the biometrics to check if there are any criminal records on the 2-year-old people too. That was introduced in 2019.
Yeah, I think that one is something that at the time when they first implemented it, we didn't think it was going to be that big of an issue, especially for those that were filing concurrently with their spouse in premium processing. You know, they did tell us that they would prioritize those that were filed with a premium processed H1 or L1. It turns out that was total lie. They did not prioritize anybody. And these processing time for I-539s just get longer and longer and longer, which creates problems for driver's license renewals and for EAD renewals for H4 EADs as well as L2 EADs. And that really led to kind of a new stance our firm took in moving into the litigation. We had never really done that before. We partnered with a litigation attorney and started providing that service because of these H4 and EAD delays that were caused simply by this silly biometrics that they added.
Also, the Fairness and High-Skilled Immigration Bill has been passed in the House. This removed the per-country quota limit, practically eliminating any discrimination that exists between one country of birth and another country of birth. However, it is at this point of time still blocked in the Senate. If this bill would pass in the Senate, that would eliminate the discrimination of some countries. I hope that will get passed in the Senate, so if any of you guys are, please fight for it. Please contact your senators.
Also in 2019, the big news that doesn't necessarily impact a lot of employment-based immigrants, but created a lot of media, I guess, stirring in the media, was the public charge rule. So this was the Trump administration's way of trying to reduce legal immigration by saying that certain types of benefits that were used or potentially to be used by immigrants would make them inadmissible under the public charge category of inadmissibility. This was supposed to take effect this past October. It also was the subject of a lot of litigation in court cases and was eventually blocked again by an injunction, but still temporary. The court cases are still going on. We still have to await a final decision from the judges in those cases. So there is a chance that the public charge rule might be back if the judges find that the Homeland Security was within their power to create this rule and they did it through all the proper procedures.
Also in 2019 is EB1 for Chinese nationals and Indian nationals is backlogged. It was all the time assumed that EB1 is a faster way of getting the green card. That happens to be not true from 2019 onwards. Going forward, we don't see that the backlog is going to be eliminated for EB1. It's going to go very slow improvement, and sometimes it may even go back also. So that's one thing we have noticed in 2019. We have also noticed that I-539s that were being filed for H4 L2s and also the H4 EADs and L2 EADs that were filed along with the main applicants that used to be adjudicated along with the H1B or L1 are no longer getting adjudicated with the main applicants. None of them get adjudicated with them. So there has been a significant delay in I-539 like H4s and L2s and EADs. Emily has already discussed on it.
Yeah, and that also causes delays for F1 applicants.
Oh, yes.
So when we've talked a lot about kids aging out, turning 21, and wanting to change their status from H4 to F1 to continue their studies, and you have to file at least a year before you're going to turn 21, and you have to file these bridge applications because the processing time is so long. So that's a major difficulty in 2019 as well.
Emily, now, there are a mixture of good news and bad news. Mostly it was bad news, and nothing good came out except that premium processing thing has been reinstated, and the new lottery system is making easier available for it. What's going to happen in 2020? What's the agenda of the government in 2020?
Yeah, I think big picture, we can say that the plan is to continue to limit legal immigration. Yes, they're trying to build a border wall to block illegal immigration, but they're doing an invisible wall to block legal immigration. There are so many regulations that we're going to go through that we're expecting to be proposed in 2020 that I think that we're going to continue to see things get more difficult.
U.S. Census Bureau has released information recently that the net immigration, that the number of people who immigrated into United States minus the number of people who have left United States in 2016 was 1,047,000, but that in 2019 is actually in 500,000. So it's less than 600,000. So that there's a significant decrease in the net immigration once this administration has come into power. Now, please make a note that there is no changes in the law, none whatsoever at all. Just the interpretation of the law has brought down the immigration from 1 million plus to under 600,000 net immigration to the United States. It's a complete fear that has been created by this administration, through which the net immigration has completely dropped down by about 40%.
So looking ahead to 2020 with EB1, like we talked about, there's been this backlog. It's not going anywhere. We do expect to see EB1 worldwide improve a little bit. The demand has slowed down for worldwide in that category, and so if that continues, it's possible that EB1 worldwide might be current again in the summer. But for EB1 India, we're not getting the leftover green cards from other categories that normally are given to EB1 India and EB1 China. So we're really limited just to the 7% cap.
Which is 2,800. In that 2,800, the family immigrants, so approximately around 200, only 1,200 families are allowed to get them EB1 green cards from India.
Yeah, so I think EB1 India is not expected to move at all in the foreseeable future. Originally, we were thinking it might move in October of this past year, and then we were thinking maybe January we'd see some improvement. That doesn't appear to be the case. It's going to be severely backlogged for years to come. We have people trying to upgrade from EB2 that also is making the EB1 even more backlogged, but it's hard to predict how much those upgrades are happening. So unfortunately, not a lot of good news for EB1 India in 2020.
DHS is proposing to have the social media questions in the citizenship application, in the advanced parole 485, which is for the green card application, ESTA applications too. This is going to be this is a way to delay all these things, is what I feel. Also, the Department of Homeland Security is proposing a 15-day work days for the premium processing. Please note that the premium processing fees has been increased in 2019, but the increase in the fees, they're also proposing to increase the number of days that they will take to adjudicate the premium processing.
Yeah, so that was announced that's what their plan is when they published their proposed fee increases. So those are likely to take effect in 2020. So premium processing is going to be counted in business days instead of calendar days. The I-485 filing fee is not increasing, which sounds great, but they're proposing to no longer include the EAD and advanced parole application fee within the 485. So you're only going to get the 485 for that fee. You're going to have, and so the 485 fee is not changing, but now you're going to have to add the EAD and AP fee to that, so you really are paying a lot more. And if your EAD and AP, I'm sorry, if your 485 is not approved within that first year, you're going to need to file renewals of the EAD and AP and pay that fee again
there are
and
some
again.
cases that the 485 is pending for 10 years because the priority date backlogs. So for each year or every other year, sometimes the EAD and advance parole is given only for 1 year, sometimes they give it for 2 years. So every other year, they will be summing up a lot of money. I mean, for a family of 4, the money might range approximately to $3,200 every year. That's a big amount of money that the people need to shell out. That filing fees doesn't exist for those applications filed on or after August of 2007. Previously, the rule was that people used to pay, the USCIS used to force us to pay for the advance parole and also for the EAD, but from August of 2007, they stopped us from paying. Now they're going to reinstate. That's going to be a humongous amount of money going to the USCIS. And please believe us in this one, that when we are paying more money to USCIS, they're not going to do any good job. In fact, they're going to do more worse job. They're going to create a bureaucratic system that will delay everything. That's how this system is right now. So it's when they're proposing all this money, the USCIS or Department of Homeland Security is not proposing anything to cut down the time. The EAD and advance parole right now for the 485 applicants is taking approximately between 8 to 9 months. So that used to be very less period of time. So even this addition of the fees is not going to cut down the timing that it's going to take. So don't believe in that they're going to cut down the timings.
Yeah, besides the 485 filing fee, pretty much all other types of employment-based immigration application filing fees are planned to increase. They're going to be increasing the I-129 filing fee. They're looking at charging different fees for different types of I-129s, whether it's an H1 or an L1 or an O1. They'll all have different fees, so that's going to be more complicated. But pretty much every type of employment-based application filing fee is expected to increase next year.
On the H-1B regulations, as far as the denial ratings, once this administration come in, has gone out like about 800%, Emily. Since this administration is coming, the denial rates have gone up significantly. Now, they're not satisfied with the denials yet. They are proposing to redefine the specialty occupation and employer-employee relationship only to make it more tougher for the companies to get the H-1B approval. They are proposing this to come this year, this regulation. If this regulation is going to be passed, I don't know what the denial ratings will be, Emily. From 35%, I don't know how much more can go.
Yeah. Also, so early 2020, we're expecting a proposed regulation to expand biometrics. So we've already talked about how biometrics, adding that to the I-539 application has really wreaked havoc on the processing times. So I can only imagine it's going to get worse if they add biometrics to maybe an I-129 filing. Who knows what else they plan on adding it to, but we should see a proposed regulation in early 2020 for that.
And that might actually kill the premium processing too, Emily.
Yeah.
Also on the EAD removal, H4 EAD removal, they're proposing the H4 EAD removal. They're proposing to propose the regulation in March of 2020. They kept on delaying it. I hope they keep on delaying this H4 EAD removal.
Another big change that we might see a proposed regulation in the spring. It doesn't necessarily impact the backlogged countries, but for those that currently can file an I-140 and 485 together when your priority date is current, they're looking at eliminating that concurrent filing. So you have to file your I-140 first, wait until that gets approved, and then once it's approved, you can file your 485 if your date is current. So we expect to see a proposed regulation on that in the spring.
Especially this is going to affect very much for the EB1C applicants. Because EB1C, there is no premium processing. It takes approximately anywhere between 18 months to 36 months to get the EB1C approval. So that period of time, they cannot file the adjustment of status. That's a very big blow for some of the countries.
Yeah, especially, you're limited on the L1 to 7 years. And if you don't start the process soon enough, you may run out of L1 time, and you don't
yeah.
have those AC-21 extensions like you do for H1s,
H1s.
based on an approved or pending I-140.
This is a coordinated conspiracy to deny the legal immigration which was been granted by the Congress. This is nothing else other than that.
Yeah.
The Immigration and Custom Enforcement is proposing to have the limitation of the stay for certain non-immigrant visa people. For example, for F1, M1, and some other people, where the I-94 is given to the duration of status, they're going to only give for a period of time that that they have to go to school. We yet don't know at this point of time, does it mean that if they complete the bachelor's degree, if they want to go to master's degree, do they need to file an I-539? We yet don't know. What if they file for the OPT? Do they need to go for the I-539 along with the OPT? Right now they just file a 765 application. We don't know if this is going to affect also the STEM extension part of it. They're expecting this proposed regulation to be coming in spring of 2020.
Also coming in fall 2020 is a proposed regulation to modify L1, specifically the L1B. So we've talked a lot over the whole year about the changes that we've been seeing in H1B adjudications. We know they're planning on changing the definition of specialty occupation. Now they're also planning on changing the definition of specialized knowledge, specifically for L1B. We've already seen L1Bs being adjudicated at a much more higher level. They're much more difficult to get approved now. I mean, it's not enough to be special. You have to be really, really special to get an L1B. It's almost like an O1 type of level. And that's, again, based on no change in regulations, no change in law. So we can only imagine if they're going to change the regulations. They're thinking of adding a wage requirement potentially to the L1 category, which doesn't currently exist. So we might see a proposal in the fall of 2020.
The unlawful presence regulations that are there, especially that is applicable for the student visa people, the Department of Homeland Security is proposing to change on that too. This especially for the people who have a duration of status, that might affect a lot of those people. The 3-year, 10-year bar might kick in. They are proposing to change the regulations on that.
We're also expecting to see some changes on OPT. So we already know that ICE in the fall of 2020 plans to issue new regulations that will amend optional practical training and how that works, probably more oversight. We don't know if they're planning on changing the duration or we don't have any specifics on that. I can only imagine it's going to be more restrictive rather than less. And on top of that, we have an ongoing lawsuit about the STEM OPT. So this goes back quite a while. We had our 17-month STEM OPT rule for several years. A lawsuit was brought saying that that was not properly, didn't properly go through the regulatory process. And the judge actually agreed and vacated the entire 17-month STEM OPT rule. We had a very tense 6-month period where DHS had to try to come up with a new rule and pass a new regulation very quickly. They did it and created the 24-month STEM extension where they added the 983 training plan. And as soon as that was done, another lawsuit was filed saying that the new STEM OPT.
The regulations are not proper.
Yeah, so that lawsuit is ongoing. It went up to the appeals court. The appeals court reversed some things and passed it back down to the district court. So it's kind of at the beginning phases of that lawsuit, but that could also impact what happens in the availability of OPT in the future. So that's kind of what 2020 looks like as of now.
Yeah, just try to, it's important if you're a non-immigrant visa person, if you're on a business visa like H1, L1, O1, P1, Q1, certain visas, it's good for you guys to come every week to understand what's going on. We did give the entire year picture of 2019, what happened, what is expected in 2020, but you still need to get the updates every week. I was on a non-immigrant visa before. I understand the things, and now things are more tougher. It's better that you need to be aware. And this 1 hour that we present is best for you to have the knowledge what you need to cope up with. Now let's go to some question answers in there.
All right, we have Supriya from YouTube, and this is actually something we talked about in our attorney meeting just this morning about the requirement to pay Medicare and Social Security taxes once a person stays in the U.S. for 5 years. When exactly is that applicable? So first, let me say I am not a tax person. I'm not a tax attorney. So let me just say that. When we're talking about taxes, what we're referring to with this 5-year rule is whether you're considered a resident for tax purposes compared to whether you're a resident for immigration purposes. They're two completely separate things, even though they sound very similar. So typically F1 students, if you're here for less than 5 years, can be considered non-residents for tax purposes and are not subject to the same withholding that everyone else is until they cross that 5-year mark. So that's probably where you're getting the 5-year change from. But other types of visas, even if you're in a non-immigrant category and you don't consider yourself to be a resident for immigration purposes, you're very likely still a resident for tax purposes and are subject to all of those
So for example, H1, H4 EAD, L1s, O1s, P1s, these people are definitely, they have to pay the Social Security taxes. No exception at all. The employer will be, if the employer doesn't pay, he'll be in big problem.
Okay, Goldie from YouTube recently got the H-1B approved in 2019 and has not obtained the visa stamp yet, planning to go for stamping, but client change happened recently or getting ready, and an amendment was not initiated. So I'm guessing your question is, can you go for stamping without having this amendment filed? And unfortunately, the answer is no. The consular officer is going to be looking for documentation of the project that you're going to work on. So they'll be wanting to see an end client letter and project documents. So if you show up at the consulate with an end client letter from a different company that was not mentioned in your H-1B petition, you're almost guaranteeing yourself a 221G. So the amendment needs to be filed first, get the approval of the amendment, and then you can go for stamping.
Prashik from Facebook has this question. Does he have to mention the part-time job history and DS-160 for the H-1B? The answer is yes, you need to list that one out. It's absolutely mandatory for you to list that. Don't do any mistake. Praveen from YouTube has this question. In all his documents, his first name is spelled as FNU, which for those people who don't know what that means, it is called as first name unavailable. It's been there since August 2011. Will that create any problem for him in getting the green card? Praveen, no, it should not create any problem. However, though, Praveen, in the 485 green card application, there is a column that will ask you a question. What other names that you may have used? Mention all alternative names, because what the USCIS will do is that they will check with the FBI to make sure that you're not a bad guy with the different names that you have. So if you have used different names, sometimes people use, my first name is actually different. It's not Rahul. It's actually happens to be Rahul, happens to be my last name, but it got messed up. I'm living with it. But when you make an application, you try to use all different names and give the alternative names to the USCIS. And then they can go and check with the databases to see if you are the troublesome guy or not. And if by any chance you miss that, that might create a problem. But just the fact that you've been FNU, you don't have a first name, doesn't create any problem by itself in getting the green card. Another question, a follow-up of Praveen, is that his priority date is December 2011. When is it going to be current? It was current until May 1st of 2010. From that point of time, it never moved. Our expectancy for 2011, if we go under the normal processing, maybe about 10 years is what I'm expecting. I may be wrong a little bit on that. Be prepared for that.
Ravi from YouTube has his H-1B visa stamped that's valid until April 2021, and then he transferred to another company and got an approval for a shorter period of time. It's only valid for 6 months. He's filed the extension and wants to know if he travels, does he need to go for stamping again? So the answer is no, assuming that your extension was timely filed before that 6 months was up. The visa stamp that is with your old employer remains valid until it expires, and you can use it if you have an approval notice with a new employer. It doesn't matter that it's got a different receipt number or a different employer name on it. As long as it's the same H-1B category, you can use that visa stamp with the new employer's approval notice.
Nancy has this question that she filed the transfer application. It's been 11 months that she filed the transfer application. Nothing happened. She filed the premium processing. What's going on? Well, yeah, that's how they are doing right now. The amount of time that it's taking for them to process has gone very significantly. What we are suggesting people is that try to get a decision before your I-94 expires. Once your I-94 expires, you will have a limited options left for you. So please don't wait until your I-94 expires. So if your company A's I-94 is expiring, and let's say, for example, of March of 2020, try to get a decision way earlier than that. That's very important. Nancy also has another question that once the H-1B is approved, which she got it until September 2020, when should she apply for the extension? This is a very tough question. Is that especially when you are working at a third-party placement where you're not working at the company location, the USCIS is looking into the MSA between your vendor and also the end client. The USCIS is also looking into the statement of work, and some of the statement of works are not available for an entire 3-year period. So, for example, if your H-1B is expiring in September of 2020 and you want to file an H-1B right now, but the statement of work only ends in June or July of 2020, it may not be a good idea to file well in advance. I mean, we recommend to apply in 6 months. That is, if it's expiring in September, so your approximately will be March would be ideal for you to file. But if your SOW is only until July, it may be worth for you to wait until July, get the new SOW, and then file the application in July. But file it in premium processing. Don't do the same mistake what you've done before and get the result before September 2020. Anything you want to add on that, Emily?
No, definitely agree with that. Coder from YouTube is on H-1B till 2021, has an approved I-140, and his wife is on H-4 EAD. He's looking to file an H-1 transfer, and he wants to know if his wife can continue to work while his transfer is in process. The answer is yes. So her H-4 and EAD remain valid as long as you are maintaining your H-1 status with any employer. So her H-4 is not tied to your employer, it's tied to you. So when you transfer and have that pending extension with the new employer, her H-4 continues to be valid and the EAD continues to be valid.
Dr. Reddy has this question that the H-4 stamping is, his wife is going for H-4 stamping. Is it good for that person to go for stamping for the Dropbox? He's actually transferring from company A to company B, and his transfer application is an RFE. Is this a good time for go for stamping? I would recommend to drop off. Don't go to stamping at this point of time. Get the approval, and then you go for the transfer, because you're not working with company A. Your company B is not approved. I would wait until the company B's H-1B gets approved before she goes for the H-1B stamping.
Sunny from Facebook wants to know, what are the chances of getting an RFE for the second time when filing an extension when there's no changes? Expect an RFE. Even though you already had an RFE on the last one and you're filing the exact same petition, there is no deference to prior adjudications. That is one of the first things the Trump administration changed when they came into office, was to remove this idea that if you had a prior approval and no changes, you were most likely going to get approved the next time around unless there was some gross error involved. Now every application that you file stands on its own, so just because you got it approved last time and nothing's changed does not mean there won't be an RFE this time around. They could even deny it this time around. Hopefully that doesn't happen, but just prepare yourself. Very possible for you to get another RFE.
Keshav has this interesting question. His H-1B is valid till 2020. He's planning to move from company A to company B with the transfer of H-1B application. He wants to parallelly file a H-4 plus EAD application. What's going to happen if what's going to happen when both H-1B transfer and H-4 plus EAD is pending? Keshav, I'm assuming that you're going to file H-4 plus H-4 EAD before your I-94 with company A expires. Now, it's called last action rule. Whichever action happens at the recent time, that will happen. Let's say, for example, your H-1B with company B is approved in February and your H-4 is approved in March, then you would be considered to be an H-4 plus EAD from March onwards. Now, reverse that. If the H-4 plus EAD is approved in February and your H-1B is approved in March, from February to March, you are an H-4, but from March onwards, you are an H-1B. And there is another way where you can switch around that by traveling outside the country. It's an easy way to do it. Some people do it by go to Mexico, but I would strongly recommend that you contact a lawyer to switch around. You can switch from H1 to H4, H4 to H4, and also the other way around. There are easy ways to switch around by traveling outside the country, but I would recommend you to discuss with a lawyer before you take any of those steps.
Venkat Siva from Facebook wants to know if it's valid to file a change of status from H1 to H4 after the I-94 has expired if the spouse that has the H-1B has a valid I-94. So unfortunately, if you are filing any kind of application with USCIS, you have to file while you're still in status, which means that before your I-94 has expired. So if you were to file the change of status after your I-94 expired, even though your spouse is maintaining H-1 status and that qualifies you for H-4 status, you weren't maintaining H-1 status at the time you filed, so that change of status would likely be denied, even if you have, for example, a pending H-1 extension. I'm assuming that's the situation where you're in. You filed the H-1 extension on time, now your I-94 expired, your extension is still pending, you're wanting to do a backup plan of filing a change of status to H-4. Even though you've got that pending extension, that's not the same as being in H-1B status. It's called being in a period of authorized stay, or POSABAG. And that is not something that allows you to file now a change of status to H-4. So unfortunately, I don't think that would be approved or be a good backup plan at this stage.
Aditya has this question about the non-protunct. What the Aditya means of non-protunct is that to request the USCIS that you want to be excused for not maintaining the status. That is the argument for the non-protunct. Aditya has mentioned that his employer forgot to file a transfer application on time. It's been 3 months. There was a change of ownership, or there is an acquisition of this company. First thing has to be determined, Aditya, is it required for them to even actually file a transfer application? Some of these acquisitions, mergers and acquisition, may not require to file a transfer application. But if your I-94 is still valid, you're considering filing a non-protunct though, I would like you to get the second opinion from a different lawyer. Don't just stick with the company's lawyer and go ahead with it. Just get a second opinion, because it's you who is going to be affected more. The company might lose a little bit money here and there, but it's your status that is going to be affected, so I would recommend that you get it. If it is a mandatory that the transfer has to be filed and they didn't file it, then definitely that's something that you definitely have to get outside consultation. Another advice, that if you were to make this non-protunct argument, I would strongly recommend to go only in premium processing. Do not do that in regular processing. Regular processing, as was the previous person was pointing out, is taking 11 months. You don't want to wait and sit down there and get the denial after 11 months.
Rajesh from YouTube wants to know if an Indian citizen is able to become a U.S. citizen, can he sponsor his wife for a green card if she is in India, and how long does it take? So yes, once a U.S. citizen is married to someone who is outside the U.S. and not a U.S. citizen, the spouse becomes an immediate relative, so you can sponsor her by filing an I-130 petition, and she'll have to go through consular processing of her green card because she's outside the U.S. I would plan on 1 to 2 years for that process to be completed.
Supriya has a follow-up question on the taxation with regards to if the person is an F1 for more than 5 years. As Emily has pointed out, that she's not that good in tax law. I am also not good in tax law. You may want to contact CPAs. They might be much better aware of the things than we are.
Vivek from YouTube is looking to file the green card soon, and he might be changing employers as well, and wants to know if he can change employers and how will that affect the green card filing. So really depends on where you're at in the green card process. If you are at the end of the process to where you're saying you're going to file your 485, which is the last step, and then possibly change employers, AC-21 allows you to take the pending green card process with you to the new employer as long as your 485 has been pending for at least 180 days and the new job is in a same or similar occupational category. The new employer has to submit an I-485 Supplement J. Assuming you've not gotten to the point where your 485 has been filed, then you can't take the green card with you to the new employer. You have to start the whole process over again, new labor certification and new I-140. You may be able to retain your priority date from the first case and move that to the second case so you don't lose your place in line if your I-140 was approved for at least 180 days before you moved to the new company.
Nandu has this interesting question. His H4 EAD is expiring in December of 2020. His wife is transferring to a different company. Can he file for H4 plus EAD? As is EAD is valid for more than 6 months from the time of filing. Nandu, I have not seen a single H4 EAD denied because they filed it more than 6 months. Though the stipulation by the USCIS says that you have to file within 6 months, though, they have not interpreted it. I strongly recommend that you file it if ever it gets a denial, which I have not seen it. The good thing that about Reddy Neumann PC is that this kind of education, what we are getting from, it's not that we are just educating, you guys are also educating. We do conduct daily conference call, Emily runs a blog, and we do have a Facebook Live and YouTube Live, and we get the information back from you too. No, we have not seen a single H4 EAD denied because they filed more than 6 months before the EAD expiration. So please go ahead and file the application. You should be fine.
iKumar1 from YouTube wants to know what happens if a person's OPT time is exhausted and they're not selected in the lottery and they're thinking of using the L1 option by working outside the U.S. for 1 year. Can they come into the U.S. on a B1 for business meetings during that 1 year period? Yes, you can, but every day you're in the U.S. is going to delay your eligibility for the L1 by 1 day. They're going to subtract the amount of time you were in the U.S. during that 1 year period, so you have to stay outside the U.S. even longer. So yes, you can technically do that, no problems with it, but the more you're in the U.S., the longer it's going to take you to actually get back to the U.S. in a work authorized capacity.
Vivek, H1B is expiring in April 30th. Can he apply for a change of status from H1 to the H4 plus EAD, or can he do the consular processing? I strongly recommend that you go through the change of status application and then join the court litigation Reddy Neumann PC does every 2 weeks. We take about 50 people every 2 weeks. We go to court and we get their approvals, because otherwise they're taking about 8 to 10 months to get the H4 plus EAD approval. Now, even if you go to the consular processing, there is no H4 consular or EAD consular processing anyway. You're going to take the H1B approval of your wife and you're going to get the H4 approval there. You come back and you file for the H4 EAD, and that's taking about 6 to 9 months too. So for all reasons, you're better off applying for H4 plus EAD here itself and then immediately join the litigation that we do at Reddy Neumann PC. You can contact us for that.
Sandeep from Facebook wants to know who can be an expert for an expert opinion letter when you have a specialty occupation RFE. So we typically will use a service that contracts with a professor at a university to provide that kind of expert opinion letter. You're not required to do that, but these services are, have dealt with many of these types of RFEs. They've vetted these professors. They make sure everything's in the right format. So we've had very good success with them. I mean, to be an expert, you just have to be an expert. You have to, if for example, if it's someone who's been in your industry for 30 years and they've been hiring people in that job for 30 years, that person might be able to say they're an expert. But in their letter, they have to explain what is it in their background that makes them an expert. I've been in this industry for 30 years. I have recruited people for this type of job for the last 30 years. And our company always hires people that have a bachelor's degree in whatever field for that type of job. It's not necessarily required to go through a service. It can be a little bit easier to do that. But it just has to be someone who can.
And what's the company that you use, Emily?
We typically use Park Evaluations.
Srinivas Madigat has this question. His daughter is turning 21 in November 2020. She's completing third year of colleges in May of 2020. She's currently in the H4 extension and she's planning to apply for the F1. One problem that I have is that whether or not she's going to get the F1 visa before November 2020. That's one problem that I have. It may be worth for you to consider her traveling outside the country and getting the stamping. Obviously, there is a chance of denial also there for F1s. Although I have, if there is something negative, I will tell you guys. I won't hesitate. Look at the first part of our video, a lot of negative news we did it. I haven't seen people under the situation like your daughter getting rejected in the F1 visa. We haven't seen that many, especially the kids who have spent their better part of their teenage in the United States going back and getting the F1 visa. Surprisingly, I have not seen. It could happen because they have to still show that they're going to return to their home country once their education is complete, and some of these kids we have to educate them what their home country is. They forgot their home country means they might say it's USA, so we might have to educate them properly. You may want to consider that. The other options is also to consider to have a B2 interim application. That may be also because once she turns 21, which is in November 2020, you can't rely on the pending H4 application.
Vibob from YouTube just got his H1B extension approved for 3 years. His current visa stamp is expiring January 5th, but he needs to travel to Mexico for 3 weeks on a business trip. So he needs to know if he has to get the stamping done, and if so, does he need to go in Mexico? So if you are traveling to Mexico or Canada for less than 30 days, in this situation, you can use automatic revalidation and come back using your expired visa stamp and your approved extension, and they will pretend that your visa is valid on the day you're entering to allow you to come back without getting the visa stamp. That only works if you don't apply for stamping. So if you decide to go for stamping and get denied, you can't then turn around and use automatic revalidation to come back.
Question from Bharat. In the current backlog condition, is it worth transferring from EB3 to EB2? Especially with the Senate 386 bill is there, how is it going to affect? Bharat, if you have the EB3 with company A and There are some things like we can have both the things also with the same company. You may want to consider that if you want to. That means that EB3 is going to remain as it is, and you can file a parallel application for EB2, and whichever is current, you can, if the company wishes to, they can proceed with, if they have two different positions, junior level position, higher level position. Yeah, if I get the green card, I want to be demoted to a legal assistant, I will. I mean, I don't care. I want to get my green card fast. So yes, you can do that under if your company is cooperative and you're wishing to do it. But to judge which one is going to be current, which one is going to go which way, it's going to be very hard to project though. Although I would admit that if the Senate 386 bill is passed though, I would assume that EB3 is going to be more forward than EB2, because the number of people who are backlogged in EB2 are higher than that of the EB2. So the number of people who are backlogged in EB2 is very higher for Indians than compared to EB3. The Senate 386 bill goes through. But it's very hard to judge if the Senate 386 bill doesn't go through, which one is going to go forward. And it's also sometimes become confusing. Let's say, for example, if Senate 386 bill passes through, if the EB3 will become current for Indians, I will convert all my EB2s on one single day into EB3 and then file the adjustment of status under the current provisions. So it immediately can change overnight from back and forth. So it's very hard to judge though. But if possible, you can maintain both the things if a company is cooperative.
Shiva Kumar from Facebook got the H-1B extension filed with the Nebraska Service Center back in June, and it's still pending. They tried to do a service request, and they're simply saying it's within the normal processing time, even though online it says Nebraska processing time is 2.5 to 4.5 months. What is going on? So you have the online processing time of 2.5 to 4.5 months, but when you call customer service, they have a invisible processing time report where they'll tell you that no, it's not actually outside normal processing time based on what the officer has. So that processing time online is not always accurate. There's a separate one that the officers look at or the customer service people look at. Your best option is please just upgrade to premium and get it over with.
Katie has this question. We see mostly people going to Canada than Mexico for stamping. Why is that? Well, I don't know, Katie. We see people going to both locations. We are located in Texas, so we see a lot of people going to Mexico too. And there is an additional burden for going to Canada is you need a visa to go to Canada for mostly, I mean, don't take me as an expert for Mexican law, for mostly they don't need a visa to go to Mexico if they're getting stamping in the border places.
Vamsi Priya from Facebook wants to know if you can use automatic revalidation to enter while the H-1B extension is pending, but you have the approved I-797 from before and a valid I-94 that has not expired. So if your I-94 has not expired, so you have that valid I-797 approval and it's just your visa stamp that has expired, yes, you can use automatic revalidation, but when you come in, you're only going to get an I-94 till the date that your old I-797 expires. They're not going to give you extra time because you have the pending extension. But once your extension is approved, then you'll get a new I-94 that extends beyond that date. However, your I-94 number is going to be changing. So you filed your extension with your old I-94 number, you traveled and came back and got a new I-94 number, then your extension is going to be approved after that with the old number. It creates this I-94 mismatch in the number on the I-94, which can actually cause problems for driver's license renewal. So that can be cleared up by traveling again, or you could attempt to contact the service center with the new I-94 number and ask them to update that in their record before they issue the extension approval notice.
Before we end the session, I have this interesting question. Sachin Agarwal has a H-1B processing to be done from F1. He wants to get his DES 160 evaluated and done by the mock interview by our firm. Yes, what I would suggest you is that to fill out the DS 160 form, not on the official site, but unofficially, and send and also give a copy of the H2B application that has been filed. We would recommend Rebecca Chen in our office would be better for that. If you want to do the mock interview, she's very good. She'll go through those things and send it to you. Especially if you got the consular processing, if you have gone because of the day one CPT University, you definitely need to get it evaluated. Otherwise, it's becoming very tough for the day one CPT universities.
Yeah, so you can go to rnlawgroup.com and click on consultations. There you'll find Rebecca Chen, and you can select her appointment time and schedule the appointment with her right online. Then she'll walk through your DS-160
And when
with
you make an appointment with any lawyer in our office, we have a system where you can upload the documents there itself, so that before they speak with you, they will evaluate, they will look into the documents that they need to when they speak with you. So we strongly recommend that to provide us as much documentation as possible to save time when you speak with a lawyer. And the lawyers in our office doesn't take much time for evaluating the documents, because we see these documents day in and day out, so it will take very quick time for us to evaluate. Even if it's 200, 300 pages, it doesn't take that much time, as much as you think, for us to evaluate it, because we're not going to look into your passport 25 pages that you're going to give it to us and look into each page and read what's there on that page. We go to the main thing and come to a better judgment. And of course, when we speak, we'll get more information from you.
All right, I think that's about time to wrap it up. Thanks so much for joining us today and every week this year. A Happy New Year to everyone. We'll see you in 2020.
Thank you, guys. Happy New Year for you guys.